Article 34.2, subparagraph B, subparagraph 2, speaks of the ground that award violates local public policy. This refers to public policy of the state, and therefore this may vary from jurisdiction to jurisdiction, from state to state. Decisions under this ground are relatively consistent in establishing that public policy is narrow in scope and should only be applied in instances of the most serious procedural and substantive injustice. Public policy should refer to a fundamental principle of law or morality or justice of the state, or the most basic and explicit principles of justice and fairness, or the very foundations of public and economic life. Other violations of public policy may be found in cases of corruption, bribery, fraud, or serious procedural irregularities. But each state has its own concept of what is required by public policy. For example, states that do not tolerate gambling, an award on a gambling dispute may be deemed contrary to public policy, but not in a state which allows gambling. Another example is in strict Islamic countries where production, sale, or consumption of alcohol is prohibited, an award on a dispute between a wine producer and its distributor may be deemed against public policy, but again, not in a state which allows the drinking of alcohol. Most developed arbitration jurisdictions have similar concepts of public policy. However, differences in public policy gives rise to the risk that one state may set aside or not enforce an arbitral award, but another state would. And therefore, in recent years, there's been a development of international public policy. An example of this is found in the new French Code of Civil Procedure, which differentiates between a national public policy and international public policy, which is less restrictive. Again, substantive grounds are not made grounds under the model law to set aside an award. So errors of fact, errors of law in the award are not grounds to set it aside. Generally, there's no appeal on law or facts. There's no judicial review on the merits. If the tribunal has jurisdiction and a correct procedure was followed, and in the final award, the correct formalities were observed, the award would be final and binding, whether it's a good award, a bad award, or an indifferent award. But in some jurisdictions, mistake of law is made a ground to set aside or an appeal an award. One advantage of this is that the risk of inconsistent decisions on the same or similar point are avoided. Also, one avoids the risk that the tribunal would not do its work as competently or as professionally as it should, if not subject to scrutiny by a higher court. But the disadvantages of this is that decisions of national judges may replace that of the tribunal that is selected by the parties. And a party may be unwillingly brought before national courts with public hearings. Also, an appeal may be used by a party simply to postpone the day of payment of the judgment award. There is a need to strike a balance between the finality of the arbitration process and the wider public interest in some measure of judicial control to ensure consistency of decisions and predictability of the operation of law. But to stress in the model law for international arbitration, it favors the need for finality of arbitral decisions. One can only look at Article 5, where it states that in matters governed by the model law, no court shall intervene except where so provided by the model law itself. Mistake of fact is rarely made a ground to set aside or appeal an award, because even if there's a bad error of fact in an arbitral award, it does not affect public interest. It is of interest only of the parties to the dispute. In summary, one restricts the challenge to excessive jurisdiction and lack of due process, One abides by the decision of the arbitral tribunal, however disappointed a party may be.